Macca's or sitting on a computer. Ultimately, you're all going to get forced into the courtroom, whether you like it or whether you don't. And at that point, you'll learn a bit of law. I'm a farmer. I learned it by walking into the courtroom. If a farmer can do it, anyone can do it. And I'm not saying that as farmers being thick as two short bricks. I'm just simply saying that I had no legal training whatsoever, but we've worked it out. What is the next question over there?
This would be to look at the sitting members, not new ones coming in.
The question is, this would be in relation to sitting members, not new ones coming in. Can you answer that question? Why? Okay, I'll answer it for you. Number one, yes, of course the sitting members have been sitting for 4 years disqualified. But who fixed the Crown problem being taken out? Until the Crown problem being taken out is put back properly, the new blocks coming in are going to walk straight into the problem. Disqualified on day one. Now they're saying and been told, ride it out, because the big players are here. We're coming in. The problem is they can't come into Australia until that current document is off the table. Would you take it off the table with what you now know? Either would I. Either would I. I'd just say leave that document right there, because as trustees of the Constitution, you've been found in breach of trust. And there's an accountability now. Next question, please. This man.
I've got a couple. First of all, the something that you showed before, there's a catch-22 with that, because you can study that stuff till you're blue in the face. When you take it to court, they can still make 1 and 1 equal 3 or 5 or 28, whatever they like. So studying that stuff is absolutely it means nothing, because it's for them, by them, and to be interpreted by them. Now the next one is...
Hang on, wait a minute, stop there. Was that a question or a statement?
Well, that's a fact.
No, it's not a fact.
It is.
Because...
You'll find out the hard way anyway.
No, that's a statement of exasperation. Do they have jurisdiction to do what you're saying they do when you know the Crown's out?
No, they couldn't give a hell. They couldn't give a damn. They did blow and gun. I said, don't worry about that. You'll see it for yourself.
How long do you think I've been doing this?
Coming back to treason, treason cannot be struck out once it's started. It cannot be struck out unless a court case is held and they found not guilty. That's the end of it. And it's also, there's no statute of limitations, so it goes on forever.
What?
Except if they die, that's the end of it.
What is the jurisdiction to hear treason?
I wouldn't know, but it's irrelevant anyway because it doesn't matter.
Why doesn't it matter?
Well, it doesn't matter because treason cannot be struck out. So once they charge with it, they're lumbered with it, and they can't get out of it unless a trial is held.
The point I'm making, when you say it doesn't matter, yes, it does matter, because that's what I'm here for. That's what I'm here for. This lady now. Stand up, please.
No, I mean, how does it matter if they win? Then it can't measure against their standards. They're okay.
What I'm actually saying is, are you already giving up?
No.
That's the point I'm making. And I'm not here to give up.
It's just one more short point. That is I think you said section 44. I'm not 100% sure, but it says there quite clearly that if a parliamentarian sits there illegally or unconstitutionally, anybody can sue them, can sue for it. And actually lists the amount, which is in pounds. In those days, it's still in pounds. But that section is so clear that any schoolboy can understand what it is.
What's the end of the section say?
Have you or anyone else tried
No.
that?
What does the end of the section say?
Well, it's been a long time
What it says in a court of competent jurisdiction. Now, which is the court of competent jurisdiction to handle this? I beg your pardon? There is one, and that's grand jury. It's the only court of competent jurisdiction. It's the only court allowed to handle treason and misprision of treason. So you still have a court left, and you haven't used it. What is the next question?
Right, it also says in that section, until the Parliament otherwise provides, and they've done that with the Common Informers Act, so they have changed the penalty only.
Yeah, totally. Next question, please. Hello, this man.
The Attorney General has substituted, has substituted the Queen, possibly make this change with the permission of the Queen on behalf of the Queen. That was back in relation to the Act to remove the oath of allegiance from the Solicitors Act.
How well do you know your Queensland Constitution?
Well, I've never read it.
I beg your pardon?
I've never read the Queensland one.
Well, no, stop there. Stop there. Because what you just said is in essence the whole problem. I will suggest that you read section 53 of your Queensland Act. Because I'll tell you what it says. That if you touch certain portions of your state constitution, you must come to the elector. Now, when you did the Australia Act, which is what you call your State Request Act, out of Queensland to the UK Parliament, all preceding the Australia Act, did that State Act touch any of those sections in section 53 in relation to the coming or pending Australia Act? In simple answer, yes it did. Now, by touching the sections that it touched, the next portion is very important. It says any person who's eligible to vote can bring a proceeding in the Supreme Court to ask for a declaration in regarding why it was contravened. Now, here's my point. Going back to your question. Anybody issue a writ? Did you issue a writ? What happened to your writ?
Well, they went into Parliament, I issued parliamentarians, and every single one of them, this includes the...
No, hang on, stop there a minute. I'm talking about the writ. The writ didn't go into Parliament.
They did, yes, and they then made an act against me, making me...
No, stop there a minute. How did you... Please stop a minute. How did a writ go into the Parliament? It should have gone into the court.
No, it did go into the court, and the Parliament, and the court went to the Parliament, and the Parliament made a law striking me out.
For what?
I beg your pardon?
For what?
They declared it was a frivolous and vexatious.
Yeah, but for what? Because you issued a writ because of what was the cause of action in the writ?
Well, I was suing John Becker Pearson at the time.
Yeah, but what was the cause of action in the writ?
Well, it was for treason.
For what?
For thwarting the Electoral Act.
In what way?
Oh, look, how long do you want? I mean, the stuff is a telephone book thing.
So what you're actually saying is you had a genuine cause of action and the court, in agreement with the Parliament, struck it out and then declared you a vexatious litigant. Now that's the point I'm making. The point I'm making is they wait for that next section to see who's going to issue any process and then they deal with you. But have they got away with it? Yes. Who said yes?
So far.
Because they haven't got away with it. That's why you're going to have a prorogued Parliament probably on this weekend, and they've got 42 days before they come back in. Now, remember where I came from. Do you know where I came from? It said it up there. From Werribee. What is the federal electorate seat of Layla? It's Julia Gillard's seat. That's in Werribee. So who will be her opposing candidate? But automatically, I'm not doing it to run whatever or get into that Parliament. I'm sitting against her the moment she prorogues it to say you are ineligible, and so is everyone in the Labor Party. So if you think this is long from over, it's not. It's only just begun. And that goes through all the High Court structures. And when you get hold of those defendants, all the High Court judges are already charged and been through the Melbourne Magistrates Court because I've locked them out, so it only goes to the grand jury. That's it. The court of competent jurisdiction. Full stop. You've got about 6 weeks to really get into your legal work and stop looking at it as though you're defeated. That's not how you play a football game. You don't walk out and run out and look at the opponents and God, look at them. And then run back into the shed. You get out on that footy field and you beat your opponent. Is that reasonable? And then you shake hands with your opponent at the end of the game and wait till the next round. Well, that's what's happening here. And if any one of you just want to say you're defeated, then please get on a plane and go and get yourself a seat in the UN. That's what I'm saying, graciously. Any other question? Please.
What are they going to convene the grand jury?
Isn't this one now?
No. I'm just wondering, right, you said a...
No, let me give you an example of why I said isn't this one now. To do that, you've got to go to the Melbourne Magistrates Court and lay the criminal charge. But I showed you that the Oath of Allegiance is out of the Legal Practice Act. What capacity does that leave the magistrate sitting in?
He doesn't have jurisdiction.
Exactly. And then when you take it across the road, which then has to go to the full court of the Supreme Court, and the Supreme Court judges have to sit to hear the application, they've got their Oath of Allegiance out. Do you understand what I'm saying? So what I am saying is by the time you get to that door, you've got 23 jurors from the electoral roll. But you do have a problem in how you're going to get a sitting panel to give you the application to go through that door. But at this point of time, all those applications are now before the court and they're pending. They were all done before they abolished the grand jury right in Victoria, which they did on January 1, 2010. Rob Hulls with his parliament did that. But it's now essentially between Julia Gillard and I in Werribee. That's the deal. Next question.
Yeah, right. Before you mentioned there was certain authorities after you with some intended indictments against you or something because of the action against Gillard and the rest of the fruit case, if I can say that. The thing is, what did they specifically, what are they alleging or accused you of?
No, let me correct you. They're not indictments. They're exactly the same as this man got. In Victoria, the Attorney General made application to his court, I'm saying his court, to make me a vexatious litigant. Now, vexatious litigant just simply means you're filing documents with no cause of action. Is this a cause of action? And I agree with this man. Of course it is. And that becomes what you call only an issue in civil jurisdiction. But when you're in criminal jurisdiction, criminal always is superior to civil jurisdiction. If you find a problem in civil, the civil issue has to sit still and they have to deal with it in the criminal jurisdiction. So they did the same in West Australia. That's just the Attorney Generals getting together to actually say, how are we going to stop this bloke? But that hasn't stopped me.
So
They're only civil writs.
So far there's no charges against you in for any...
I would love a charge. Do you know why? Because then I have to go to a jury. That's why they won't charge me. The only thing they've done is civil writ because their own judiciary hears it. But they don't dare file a criminal charge. Why? Because then I'm the defendant and I've got to get a jury. They won't give me a jury because they know the whole... See, when the DPPs first started intervening, state DPPs, they managed to get, one day when I went to the bar table was full, there was no room there. And they said, we're here to make an application for cost against you for filing these charges. To which the magistrate said, aren't you all on salary? I said, yeah. Well, why would you make such an application against a man who's only doing what he's legally right to do? Do you know what they said? To teach him a lesson. They wanted $9,000 on that day. And she said, I'll reserve my decision. She would give a written decision in a week. Now, what it said was that if you wish to seek cost, you have to permit Mr. Shaw to do the cross-examination of the evidence he's produced by putting the DPPs in the witness box. They immediately withdrew the application. That's why. Now, going back to your question, in relation to my cost order from the civil writ in Western Australia, that's $25,000 at the moment. The person who costed that was Corey Rayner, at the time a registrar of the Supreme Court of Western Australia. Corey Rayner was murdered shortly thereafter in a body found in Kings Park. But